Hello, I am Surya Subedi. I am Professor of International Law and the author of the study guide on international investment law. Today, I will discuss very briefly what is in section B of this study guide. As you know, there are 4 sections in this course, international investment law. Section A deals with the evolution of international investment law, and section B, which I am discussing now with you, deals with the international efforts to regulate foreign investment. Unlike other areas of international law, for instance, international human rights law, even the law of the sea, there are number of treaties, comprehensive treaties, international treaties negotiated by a diplomatic conference or under the auspices of the United Nations, but in the area of international investment law, there is no single global comprehensive convention. Hence, you need to look at customary international law, you need to look at bilateral investment treaties, you need to look at other soft law instruments adopted under the auspices of the United Nations, whether General Assembly or the Economic and Social Council or some other United Nations agencies, even the United Nations Human Rights Council, which got involved in the work of in the area of business and human rights, just to give you an example. Therefore, this section is designed to present a survey of the evolution of international investment law and the efforts made by international organizations to codify or to develop international investment law. I begin with an analysis of the developments taking place before the Second World War and then go on to outline in greater detail, because that is where the development has taken place in the post Second World War period, most exciting period for the development of international investment law. First bilateral investment treaty concluded was in the late 1950s. Then since then the number of bilateral investment treaties began to grow and grow. Now there are about 3,000 of them. Every state which has a policy to attract foreign investment has negotiated and concluded bilateral investment treaties with the countries concerned, from where the foreign investment is likely to come. And of course, sometimes bilateral investment treaties between two countries by definition may not be sufficient. A group of states would like to come together and have a common policy put in place, and there have been regional investment treaties as well. Therefore, the survey in this section includes the evolution of both bilateral investment treaties and other international efforts under the auspices of the United Nations. As I said, the United Nations was at the forefront of the efforts to regulate foreign investment in the 60s and 70s under the idea of new international economic order, which was very much the name of the game within the United Nations in the 1970s. Within that one, there was an ambitious program of regulation of foreign investment, but nothing concrete, nothing much came out of those endeavors. Of course, soft law instruments were adopted. For instance, the 1974 Charter of Economic Rights and Duties of States is a result of that endeavor, but it is a soft law instrument. Of course, some of the provisions of the Charter of Economic Rights and Duties of States of 1974 have now been regarded as part of customary international law, because many authors and international courts and tribunals have regarded that one as declaratory of customary international law. Hence, the course includes an analysis of instruments like the Charter of Economic Rights and Duties of States of 1974, the Rio Declaration of 1992 and number of other instruments, and then goes on to look at the work of the organizations like WTO. What has the WTO been doing to regulate foreign investment? What have the organizations like the World Bank and IMF have done? For instance, World Bank got involved in the idea of regulating foreign investment quite early on in its existence. In 1965, under the auspices of the World Bank, a very important treaty was concluded known as the International Convention on the Settlement of Investment Disputes, which established the International Center for the Settlement of Investment Disputes known as ECCID. So, these are the attempts made by the United Nations, the World Bank, the IMF, the WTO, and of course, we should not forget the very important contribution made by the OECD to regulate foreign investment. The OECD has been quite ambitious from the very beginning to come up with a treaty which will regulate foreign investment. United Nations very much a political body, but OECD more of an economic body, perhaps more suitable to come up or to negotiate a comprehensive convention on international investment or investment protection. So, the OECD got involved in the 1960s, but much of its work has been in the form of guidelines, which is I would say a soft law instruments, guidelines which will which have included provisions designed to regulate foreign investment. But in the 1990s, the OECD became more ambitious and decided to embark on a project to negotiate and conclude a comprehensive global convention on investment protection known as Multilateral Agreement on Investment, or some people refer to it as MIA, Multilateral Investment Agreement. But unfortunately, that endeavor also did not result in a successful conclusion of a global treaty. There were differences of opinion between states and other civil society organizations. Many people thought what the OECD was trying to negotiate was rather pro-investment, rather than balancing the interest of developing countries and developed countries and coming up with a balanced international treaty. As a result of that one, the attempts of the OECD did not succeed. So, today there is no international organization which has the regulation of foreign investment on its active agenda. But if you put together a collection of hard law and soft law instruments, you will come to have a proper appreciation of the body of law that already is existence in international investment protection. And that is the focus of this course, gives you a good overview of the evolution of international investment law and the current state of affairs, where we are today and where the law stands, and that is the focus of the content in section B of this course. Thank you.